Which cryptocurrency is being attacked by the SEC after XRP? How long will crypto holders believe in Ripple? How much will XRP cost in mid-2020? 3. We will answer one of Ripple's primary arguments against allegations that it marketed unregistered securities in connection with XRP has been the subject of a filing exchange between Ripple and the U.S. Securities and Exchange Commission. With the fair notice argument, Ripple intends to counter the SEC's motion for summary judgment in its favor. Ripple claims that the sale of XRP is not illegal because it did not have fair notice that doing so would be illegal, which is an affirmative defense under U.S. law. The fair notice defense may not be available to Ripple, however, because to recent legal judgments on the topic. In SEC vs. Commonwealth Equity Serves LC, decided earlier this month, the court also rejected a fair notice argument based on the identical facts as those presented by Ripple, and the SEC has now pointed the court in that direction. In particular, it decided that the defendant couldn't use the fair notice argument since the SEC's accusations were founded on a Supreme Court ruling from the 1960s. Even if the defendant claimed that the SEC had known about the harmful behavior for over 2 decades, this was still the case. In other words, the SEC's lack of prior enforcement of a regulation is not a reason for its violation at the current time. The SEC contended that the court should come to the same result since the SEC's argument is similarly founded on decades-old Supreme Court precedent, the Howey test for assessing whether an offering amounts to an investment contract and hence is a securities offering. In a brief, Ripple quickly responded, explaining that the Commonwealth case could not apply because the defendants there adduced no contemporaneous evidence supporting its defense that market participants lacked fair notice. Unlike its own case, Ripple claims there is abundant evidence showing that average people didn't consider the sale of XRP to be a security offering. Furthermore, the defense contended that the court should uphold the defendant's fair notice argument since it did so in Upton, the case upon which Commonwealth is founded. Even though Upton held that the defendants in that case could rely on a fair notice defense, a U.S. federal court has already ruled that Upton does not apply in Howey securities cases, so Ripple's response stands out. Although it is unclear whether or not XRP was launched via an ICO in the Ripple case, the fair notice finding against Elbry does not depend on this issue, and Ripple has taken the same stance as Lawbry, that it did not launch through an ICO. Although these precedents are not binding on the Ripple court, it is impossible to deny their persuasiveness. The fair notice argument is unlikely to rescue someone who fails the Howey standard. The Ripple vs. SEC court case has been going on for 2 years and 120 days, and the judgment date is still unknown. While numerous legal experts think the ruling is close, it is unknown when it will be made public. The lawsuit has strained relations between the SEC, the Commodity Futures Trading Commission, CFTC, Congress, and the cryptocurrency sector, putting enormous pressure on Judge Annalisa Torres. According to XRP community attorney John E. Deaton, the Ripple vs. SEC court case is the most important no-fraud SEC enforcement action since 1946. He also said that considering the gravity of the case, Judge Torres is taking her time and carefully evaluating every statement. If the verdict goes against Ripple, Judge Torres understands she's dealing with a conservative court, and if it goes in Ripple's favor, she will have to defend it to everyone. Based on past orders by Judge Torres, lawyers John Deaton and James K. Phelan believe a verdict will be issued by the end of April. Ashley Prosper, an XRP community member, has also anticipated an eventful week, noting Judge Torres' judgment on the Daubert petitions, which took 52 days to resolve. Given the importance of the Ripple vs. SEC court case for global commerce and banking, Judge Torres has been subjected to enormous pressure. While the decision is anticipated shortly, it is unknown when it will be made public. The lawsuit has significantly elevated the stakes for both Ripple and the SEC, and the crypto world is waiting for the verdict with bated breath. Ripple and the SEC have been locked in a heated court fight for over 2 years over claims that the blockchain startup issued and sold XRP as an unregistered securities. The SEC has argued that the dominant blockchain firm broke the law when it sold XRP, and it has asked the court for a summary judgment in its favor. Yesterday, SEC Chair Gary Gensler testified before the House Financial Services Committee and was asked a number of questions about recent events in the Bitcoin market. The SEC was asked a number of crucial questions, one of the most pressing being whether or not he considers XRP to be a security. Congressman Warren Davidson posed a crucial question to the SEC chairman, asking whether he considers XRP to be a security. The chairman of the SEC declined to answer the question categorically. The head of the SEC has instead said that the question of whether or not XRP is a security is now being debated in court. We are in court, and that there are active discussion and litigation on that matter, Gensler added. When asked if Ethereum, ETH, is a security, Gensler again declined to say yes or no. Given that the head of the SEC has insisted that XRP is a security, his reaction caught many crypto fans off guard. Last year, Gensler shared this sentiment, stating that Bitcoin is the only cryptocurrency he believes to be outside the purview of the SEC. Many others thought Gensler was unqualified to lead the agency because of his tough stance on enforcement in the financial markets, notably the cryptocurrency industry. Interestingly, Representative Warren Davidson, R.O., felt similarly and submitted legislation calling for Gensler's ouster and a reorganization of the SEC. Chairman Gensler, your record of failures to protect investors and abuses of power make it clear that we need to restructure the Securities and Exchange Commission, stated Davidson. Rep. Davidson filed legislation to remove Gensler as SEC chairman after he detailed some of Gensler's shortcomings and abuses in office. Davidson said, to correct a long series of abuses, I'm introducing legislation that removes the chairman of the Securities and Exchange Commission and replaces the role with an executive director that reports to the board where all authority would reside. Judge Annalisa Torres has not yet issued a ruling in the case of Ripple V's. The SEC. Ripple may benefit from the legislation intended to remove Gensler. Judge Torres will undoubtedly feel pushed to decide in favor of Ripple as a result of Congress casting light on Gensler's ineptitude and misconduct.